Welcome to Same Day, Different Century. I'm Zach. Today is August 10th. On March 19th, 1993, Justice Byron White informed the White House that he would step down at the end of the term. White had sat on the Supreme Court for 31 years, appointed by John F. Kennedy. His departure handed Bill Clinton something no Democratic president had held since Lyndon Johnson named Thurgood Marshall in 1967. 26 years had passed. There was no bench of vetted candidates and no institutional memory of how to do this. Clinton took 87 days. He wanted a politician, someone with a record of governing rather than judging. Mario Cuomo, the governor of New York, was courted and removed himself from consideration. Bruce Babbitt, the Interior Secretary, drew warnings from Western Republicans, and Clinton was reluctant to empty a cabinet post. In June, the search narrowed to Stephen Breyer, Chief Judge of the Federal Appeals Court in Boston. Clinton met Breyer on June 11th. Breyer had come almost directly from a hospital, having broken some ribs and punctured a lung in a bicycle accident. By most accounts, the president came away unpersuaded. The name that rose late belonged to a 60-year-old judge on the Federal Appeals Court in Washington. Ruth Bader Ginsburg had graduated at the top of her Columbia Law School class in 1959 and could not get hired by a New York firm. Her clerkship came after a Columbia professor, Gerald Gunther, pressed a district judge to take her. By Ginsburg's own telling, promising a replacement clerk if she failed and threatening to send him no Columbia students if he refused. By 1972, she was directing the American Civil Liberty Union's Women's Rights Project and teaching at Columbia Law School as its first tenured woman. She argued 6 sex discrimination cases before the Supreme Court and won 5. She often brought men as plaintiffs, including a widower denied the survivor's benefits a widow would have received, to show justices that laws sorting people by sex injured everyone they touched. Jimmy Carter put her on the appeals court in 1980. Over 13 years there, she voted frequently with conservative colleagues and wrote narrowly. Her husband, Martin Ginsburg, a tax lawyer with wide connections, organized letters and calls on her behalf. Senator Daniel Patrick Moynihan pressed her name directly on the president. Clinton met her on Sunday, June 13th, and announced her the following afternoon. She ended her Rose Garden remarks by speaking of her mother, and of hoping to become what that mother might have been in an age when women could aspire and achieve. What nearly cost her the nomination was not anything she had written as a judge. It was a lecture she had delivered 3 months earlier. In March 1993 at New York University, Ginsburg had argued that Roe v. Wade went further than it needed to. The court, she said, had reached beyond the Texas statute in front of it and short-circuited a legislative debate already moving, and it had grounded the right in privacy when equal protection offered firmer ground. Abortion rights organizations read the lecture uneasily. Several urged Clinton to pick someone else, but once Clinton named her, none of them fought her. For Senate Republicans, the lecture read as reassurance, and they were operating in an atmosphere shaped by 2 recent fights. Robert Bork had been rejected in 1987 by a vote of 58 to 42, after days of extended argument about his published views. Clarence Thomas had survived in 1991 by 52 to 48. Orrin Hatch of Utah, the ranking Republican on the Judiciary Committee, later wrote that he had recommended both Ginsburg and Breyer to Clinton as nominees who could be confirmed without another rupture. The hearings opened on July 20th before a committee chaired by Joe Biden and ran 4 days. In her opening statement, Ginsburg set out the boundaries she would hold. A judge sworn to decide impartially, she said, can offer no forecasts and no hints. To do otherwise would show disdain for the whole judicial process. But on abortion, she was unusually direct for a nominee, telling senators the decision belonged to the woman, and that when the government takes that decision from her, she's treated as less than a fully adult human responsible for her own choices. She spoke at length about the equal protection framework she had spent a career building. On the death penalty, on cases she could imagine reaching the court, and on much of the rest, she declined. The combination frustrated senators on both sides of the table, and it would draw sharper criticism later, including from a young lawyer on Biden's staff named Elena Kagan, who later became a Supreme Court justice in 2010. That posture became the template. Nominees after her would invoke the boundary while rarely matching her candor on the one issue she chose to address. The Judiciary Committee approved her unanimously on July 29th, and the full Senate voted on August 3rd. She was confirmed 96-3. The three opposing votes came from Republicans: Jesse Helms of North Carolina, Don Nichols of Oklahoma, and Bob Smith of New Hampshire. 7 weeks had passed between the announcement and the vote, and only 3 senators said no. On the morning of August 10, 1993, in the court's oak-paneled conference room, Chief Justice William Rehnquist administered the judicial oath. Her husband held the Bible. Later that day, Rehnquist gave her the constitutional oath again, in the East Room of the White House, with the president watching. Ginsburg was 60 years old. She became the 107th Justice of the Supreme Court, the second woman ever to serve. With Sandra Day O'Connor already seated, 2 of the 9 were women for the first time. The court's formal investiture came on the 1st of October, and she took her place for argument when the new term opened days later. The image most people now hold of Ginsburg was formed later and looks little like 1993. She arrived as a consensus choice, backed by Republicans who read her record as restrained, and greeted warily by some on the left. In 1996, the court struck down the Virginia Military Institute's exclusion of women, 7-1. Ginsburg wrote the opinion, and 6 justices signed it. A state defending a sex-based classification, she held, must offer an exceedingly persuasive justification. The reputation that outgrew her came from losing. In 2007, she dissented in a pay discrimination case brought by Lilly Ledbetter and read the dissent aloud from the bench, a device justices reserve for deep disagreement. She invited Congress to fix what the majority had done. Congress did, in a law signed in January 2009. The majority in Ledbetter's case had held that the clock for filing a pay discrimination complaint started running when the employer first set the discriminatory salary, a decision an employee often has no way of knowing about, since pay is rarely disclosed. Ledbetter had worked at a Goodyear plant in Alabama for 19 years, before an anonymous note told her what the men in her job were earning. The Lilly Ledbetter Fair Pay Act of 2009 reset that mechanism. Under the new rule, each paycheck issued under a discriminatory decision restarts the filing window, and recovery of back pay reaches up to 2 years before a complaint is filed. Congress applied it retroactively to the day before the court's ruling. It was the first bill Barack Obama signed as president, on January 29, 2009. Ginsburg served 27 years and died on September 18, 2020, at age 87. Her seat was filled that October by Amy Coney Barrett. That same day, different century. I'm Zach. We'll be back tomorrow with another date, another story. Thanks for listening.